the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd ask that you all remain standing for a moment of silence in honor of our soldiers, past and present. Thank you. I'd like to announce that this meeting is being recorded by Dartmouth Community Media, and also that our next regular scheduled meeting of the Board of Appeals will be on Wednesday, August 27th of 2025. Moving on to the public hearings portion of tonight's meeting, the first matter we have on is an administrative appeal, and the petitioner is Jeffrey P. Medeiros, Esquire. The owner is Augustino and Maria C. Pont. The subject property is located at 146 Chase Road, and the map is map 45, lot 31. It's located within the single residence B district. This petition was legally advertised on July 31st and August 7th.
I make a motion that we waive the reading of the abutters.
Second.
All in favor?
Aye.
Aye, the ayes have it. Does anyone in the audience or anyone at home who'd like to review the abutters list as to who was notified? We have that list available at the Zoning Board of Appeals office here in Town Hall. The petitioner in this case is seeking an administrative appeal to appeal the decision of Randall Bassett, Director of Inspectional Services, regarding map 45, lot 31, which he determined under Mass General Law 48, Section 6 does not meet the requirements and therefore not a buildable lot. This differs from the previous determination of the former building commissioner. So, let's see, is there any comments from anyone here? I don't believe that there are. Excuse me? I read that already. Yeah. All right. Let's see. So, planning, there's some comments here from town boards. Planning Department says, this lot is subject to the conditions outlined in a special permit granted by the Planning Board dated January 23rd, 1990. Oh, excuse me, this is the wrong packet. I apologize, it's got mixed in.
Just take that.
Yeah, I got it here. Just that got mixed in. Let's see what we got here. So I got a letter from the building inspector. Building inspector, it's from, here we are. This is dated July 16, 2025. This is addressed to Augustino Maria C. Pont, and it's from our building inspector, Mr. Randy Bassett. It says, please be advised that I've reviewed the information submitted to this office. Massachusetts General Laws 48, Section 6, any increase in lot area, frontage, width, yard, or depth requirements of a zoning ordinance or bylaw shall not apply to a lot for single or two-family residential use, which at the time of recording or endorsement, whichever occurs sooner, was not held in common ownership with any adjoining land. Conform to then existing requirements and had less than the proposed requirement, but at least 5,000 square feet of area and 50 feet of frontage. In Preston versus Board of Appeals of Hull, the court held that even where vacant lots were in separate ownership at the time of a zoning change that rendered them non-conforming, they nonetheless merge when they subsequently come into common ownership. While a town may choose to adopt a more liberal grandfather provision, it must do so with clear language. See Marinelli versus Board of Appeals of Stoughton. The lot located at 146 Chase Road, map 45, lot 31, has 196,681 square feet of land with 54.47 of frontage. Lot 31 came into common ownership control on March 6, 1998, when Mr. Cooper, owner of Lot 12, purchased it. Once acquired by the revocable trust, Mr. Cooper had the ability to transfer or convey both lots. 12 and 31 have merged for zoning purposes. It is my opinion that based upon this information, the lot located at 146 Chase Road does not meet the requirements of 48 Section 6 and is therefore not a buildable lot. This determination does not guarantee conformance with other laws and regulations. It is the owner's responsibility to check with other departments, i.e. health, conservation, etc., to ensure full compliance. And please let me know if you have any questions, and it's signed by Mr. Randall Bassett. So this is the denial letter, gentlemen. So we don't get too many of these, but I also want to read into the record, which is what gives rise to what we have here, and it's a more recent letter from Mr. Braga, who was our prior building commissioner, and it was addressed to Attorney Jeffrey Maderas back on July 6th of 2023. I have reviewed your zoning opinion inquiry for Lot 4531. It should say map 45, lot 31. Based on the information provided to me, it is my opinion that this lot, for zoning purposes, meets the requirements of Mass General Law 48, Section 6, non-conforming law, and Article 6, Section 375-6.3b of the Town of Dartmouth zoning bylaw for non-conforming lots. A favorable zoning determination does not guarantee conformance with other laws and regulations. It is the owner's responsibility to check with other departments, i.e. health and conservation, et cetera, to ensure full compliance. Please feel free to contact me with any questions you may have. The subject property is located in the Single Residence B District and respectfully signed by Joseph Braga. All right. And this is a letter that was addressed to Mr. Braga, and it came from Mr. Jeffrey Maderas of the Law Office of Burke, Espanola, and Van Colen. And it said, Mr. Braga, dear Mr. Braga, please be advised that this office represents Agostino Maria Ponce with regards to purchasing the above property. The Ponce, in the course of performing their due diligence with regard to the property, are requesting an official zoning opinion letter under 375-34.3 regarding whether the lot in question meets zoning under the Town of Dartmouth zoning bylaw. The Ponce's inquiry as to whether the above lot meets the requirements of Section 375-6.1, and in particular 375-6.3 of the zoning bylaw as a pre-existing non-conforming lot of land in the Town of Dartmouth. To assist you in your determination, I have included the deeds of the property and a rundown from the title examiner. A 45-acre parcel of land was purchased in 1935 by John Jacobson, which included the property in question. Mr. Jacobson transferred several lots from the larger piece from 1935 through 52. The Town of Dartmouth and the Commonwealth of Massachusetts took large portions of the land by eminent domain. The remaining portion of the land consists of approximately 4.52 acres, which has over 50 feet of frontage on Chase Road. The Ponce understand that if the lot in question is determined to be a pre-existing non-conforming lot in accordance with the bylaw, that they will need to meet all of the current building requirements regarding the upland requirements, sideline and setbacks, as well as any wetland buffer. Signed, Mr. Jeffrey Maderas, actually Attorney Jeffrey Maderas of the Law Office. All right. I guess we got another letter from a building inspector, but we'll leave that for now. So at this time, I'll call upon the petitioner or the petitioner's representative to state their case.
Good evening, Mr. Chairman. My name is Jeffrey Maderas. I'm an attorney in the city of Fall River, Mass. with the Law Office of Burke, Espanola, and Van Colen. The reason why we're here this evening is especially with regard to the land 146 Chase Road in North Dartmouth. You've gone over the map and lot of the property owned by Augustino and Maria Ponce. In the process of them purchasing the lot, we had to do our due diligence. So to do the due diligence, the first thing we did was I made an appointment with Mr. Braga to meet with him at Town Hall to go over the particulars with regard to the purchase. I asked him if a building permit could be issued on this land. He said to issue a building permit, the first thing that Mr. and Mrs. Ponce had to do is purchase the property. So to purchase the property, they then had to submit a septic plan, they had to submit the site plan, they had to submit building plans, and also meet with the different groups in the city, in the town, with regard to conservation, the Board of Health, planning, and so forth. So he basically said I should go talk to those departments. I said I would, and that's when we started hitting the different departments on that day. When we went to the Board of Health, I spoke with, and I'm sorry, I never wrote her name down. I told her the property address, asked if there was perks, and if I could have copies of the perk that were done for that property. They were done in 2019. She said they were never certified, even though a person from the Board of Health went, visually inspected the perks being done. The engineer that did the perk test never submitted his final engineering to the Board of Health, so they weren't valid. I then went to Conservation, talked about the wetlands where the house would have to be put. He said basically you had to follow the 100-foot buffer zone. He said it's now 2022. When I met with Mr. Braga, October of 2022, he said that he strongly suggested that a new wetland study was done. So I thanked everybody for their help, went back to my office, called the seller of the property, said, your perks aren't any good. You also have to do another wetland study as part of our due diligence. He then, engineering on that property took several months, so we went from August of 2022, I'm meeting in October of 2022, and then the letter that I wrote to Mr. Braga was June of 2023. So that was the final step in the process of whether or not Mr. and Mrs. Pont were going to purchase the property. I had a conversation with Mr. Braga on the phone regarding the property that was sold in 2019 from the Cooper Nominee Realty Trust. They sold the lot in 2019 of 150 Chase Road. The property that Mr. Pont was buying was in the Earl Cooper Revocable Trust. So the conversation that I had with Mr. Braga regarding if the property was in common ownership, I had looked at 3 deeds that Mr. and Mrs. Cooper had purchased the property at 150 Chase Road. Those deeds were not by tenants by the entirety. They were joint tenants. So they specifically said that Mr. Cooper and his wife, Marjorie Cooper, were purchasing the property as joint tenants and not tenants by the entirety. The trust that Mr. Bassett referred to, the Earl Cooper Revocable Trust, was a trust that was set up by Earl Cooper. He was the trustee. Marjorie Cooper was not the trustee of that trust. It was just Earl Cooper. So my opinion at that time was that there was no merger since, as you know, in real estate law, there's 3 tenancies that are available to someone: tenants in common, joint tenants, and tenants by the entirety. Tenants in common is a 50% ownership, and that for those individuals. Joint tenants, they each had a 50% undivided interest. So Earl Cooper had a 50% undivided interest. Marjorie Cooper had a 50% undividable interest, and it wasn't the tenant's entirety, which husband and wife normally do, and it would be one person. Joint tenancy can be broken at any time. I'm sure Mr. Medeiros knows that, with somebody conveying their interest out of the joint tenancy to someone else. So Mr. Cooper had a 50% undivided interest in 150 Chase Road, and Mrs. Cooper had a 50% undivided interest in 150. Mr. Cooper was the trustee of the Earl Cooper Revocable Trust. I received a letter from Mr. Braga on the inquiry as to whether or not, or the zoning opinion inquiry. I received a response via email. That email was favorable. It's the copy of the letter that you have in the packet, saying that it met the requirements of the zoning bylaw. And then based on that letter, we basically closed on the property. It took Mr. and Mrs. Ponce approximately 2 years to get all the engineering done, the house plans. Their son was the general contractor, and he suffered he passed away unexpectedly in January due to an auto accident on 195 eastbound. So the building permit, it took a while to basically get applied for, and then when Mr. Pont was told that they couldn't build, and that's when we then sent the information that I had sent to Mr. Braga to Mr. Bassett, the new zoning enforcement officer. So, but for the letter that Mr. Braga sent to me in July of 2023, we wouldn't have closed on this property. But we closed, and we detrimentally relied on that letter from Mr. Braga to the sale.
All right, anyone have any questions about what he just described?
I don't have any at this time, but I will.
Attorney Maderas, you've done the title to this piece of property?
I've done the title for 146. I didn't do the title for 150. I looked at deeds for 150, and
46 is the one we're here on.
that is correct. I did the title on that.
And 146 was owned by who?
Mr. Jacobson, if you saw the
Right,
assessors,
but then it was bought by an irrevocable trust?
revocable trust,
Revocable
the
trust.
Earl Cooper Revocable Trust.
And that's who your client bought the property from?
Correct.
And do you know who you said the trustee was Earl Cooper, correct?
Correct.
Who were the beneficiaries, if you know?
I can't recall that. I don't know, but
Was it Earl Cooper?
I would say that it could be Earl Cooper. His wife was not the successor trustee. His daughter was the successor trustee of the property. There was contingent beneficiaries, which the wife was a contingent beneficiary.
Okay, so this is a public hearing. So at this time, we allow people to speak, and I understand that someone raised their hand. So if there's anyone in the audience that would like to speak in favor of this petition, is there anyone in the audience that'd like to speak in favor? Before we take the next step, I just want to clarify one thing. Mr. Maderas, you and I share the same last name. But
We're not
rel-
family members.
We're not related, right?
I'm from the Fall River, Maderas.
Okay.
What are you talking about? You're all related.
I just wanted to make that clear. Maderas is like.
I should have stated that.
Okay, thank you. Now, so is there anyone that would like to speak in favor of this petition? So now, there not being anyone in the audience to speak in favor, is there anyone that would like to speak in opposition of this petition? I ask that you come up, identify yourselves by stating your name and your address so that we know where you reside in relation to this property. Feel free.
I'm James Tooley, Tooley, 176 Chase Road. I'm in a butter. I've owned the property since 1978, so a long-time homeowner and as well as a veteran. I knew Mr. Cooper, who owned, and his wife died before him, and then Mr. Cooper, lived there, and then they were in a nursing home. And when he bought that land from Mr. Jacobson, he pretty much told all of us, our butters, he bought that so that no one would ever build there because of the concerns about all the years with UMass and the water. We get a lot of, there's a brook that runs behind us, and we get a ton of water. And so any building on there he was concerned about. But unfortunately, it seems like after Mr. Cooper died, his children became, I think, or one of them became owners of the property. And I think, even though I spoke to them and told them their father had said to us, I think, they wanted to sell it and unfortunately probably make some money on it. But the fact is that he never wanted anything built there. And I guess the concern I would have is that if there is laws that prevent it from being built that are enforceable, as the new building inspector has said, I would support them going. I feel bad for people who have invested money, and there's obviously a concern about that the Coopers either shouldn't have sold it or more should have been done to investigate whether it's buildable or not. But I do worry about the water that could, the wetlands behind where I live. There's a brook, and it always overflows, and it goes to our neighbors, and it's always been a problem. It became more of a problem when UMass added more, structures up there as well. But so as an abutter, I would be against a house going in that location.
Thank you.
Can I just ask you a question?
Sure.
You mentioned that Mr. Cooper told you that he bought that property so that nobody could build behind
Yeah,
it.
he bought it from a person by the name of Jacobson. I guess at the time he was in Alaska, and he told all of us that, that knew Mr. Cooper. He was a great guy, a veteran as well from World War II, Navy, and he said that he bought that land with the hope that he didn't want anything built behind there because he knew all of us and that were abutters to that land were behind us. He owned the land behind myself, behind the veterinarian building, behind Mr. and Mrs. Brito, and obviously behind his own house, and it was bordered right where the Thomases used to own. All that land was owned by Jacobson, and Mr. Cooper bought it with the hopes of no one ever building there.
But I understand that that's what you said, but isn't it a fact that Mr. Cooper turned around and sold that property?
Mr. Cooper didn't sell it.
All right, but the trust that he had?
He died, and his children sold it, not...
Okay, that's what I didn't understand. So the children sold that property for $200,000.
That's right.
All right, thank you.
Yeah.
If I may, sir, if you'd be so kind to come up here and show me where your address is in relation to this, you could take a quick look. So this is the frontage, you see the frontage there? Yeah, right there. All right, could you put a nexus to where your lot is? Okay, thank you.
Which lot is it?
I'm gonna show you guys.
What's the
It's the
number?
one that abuts the wetland area where there's gonna be no development. Yeah. Okay.
4527?
Where you marked off, it's 4527, map 45, lot 27.
Oh, 4526.
4527. Thank you, sir. You're welcome. All right, is there anyone else in the audience that would like to speak in opposition?
Good evening. My name's Kathleen Brito. I reside at 179 Chase Road. I am here representing, I'm trustee for my mother's property. She's alive, she's 95 years old, so she couldn't be here tonight. My parents built that house in 1955, the year I was born, and I grew up next to the Coopers. Mr. and Mrs. Cooper, if they were alive now, would probably be around 100 years old. Mrs. Cooper went into assisted living, and Mr. Cooper remained in the house for a period of time, and then he joined her. They had 3 surviving children. They lost a son to an accident on the Well Road back when he was 17. There was a daughter lives in Dartmouth, a daughter lives in Texas, and a son lives in Florida. They inherited the estate from their father, from their father's trust. They sold the house. It was flipped, revamped, and sold. It was also our understanding that he just purchased the land so that no one built back there. It was always looked at as unbuildable because of the wetlands. My understanding is the property is only about, from east to west, is only about 180 feet, 50 yards or so. Is that correct?
Well, at its narrowest point, it's about 50 some odd feet, and then beyond that, it's much wider than that.
Right, but at the max, say behind 158 and 150. About 50 yards? A little over 50 yards.
I can tell by this, but
Anyway, my parents never had water in their basement till UMass was built, and then the first spring came, and it flooded, and the animals came running out of the woods. And ever since then, there has been water in the basement, which you would figure that's lowlands, but it's just the way the water goes. Runs behind the veterinarian next to my mother, runs behind the Tuoleys, there's a brook, and goes behind the Steele property, and then the brook goes underneath Chase Road. When it rains, the Steele's property is flooded, and so is Chase Road. So my understanding is that this is denied because that piece 146 was connected to 150. And that it was like as an entire thing, and that it was buildable when it was connected to 150, and then when it became disconnected from 150, that's why it's being deemed unbuildable. Am I correct in that?
Ask it, when you say 150, you're talking about the...
She's talking about the house numbers. We don't have house
those
numbers.
house
Okay,
numbers.
150 is the
Well,
Cooper's,
how about we
was the
clarify this?
Cooper's residence.
Can you do me this favor? Can you put on here, put an X as to where you believe your mom's house is located? Mr. Tully put the X here. Do you see the X?
Right.
Okay. Where's your mom's house?
Am I missing something
Okay.
here? That gentleman's house is there?
enough.
Yeah.
Fair enough.
Where's hers?
This is the veterinarian, and this is Cooper's house here.
Okay, thank you. Thank you.
Can I see that, Mr.
Absolutely.
Chair? Wait, where
That's
is,
the Cooper property right there.
yeah, so that's her property right there, right?
Cooper, and that's Brito.
You know, where's the vet?
The vet's the other property that's not
I mean, Tully's and my
This one
mother's.
here, here's the vet, right there.
Oh, so opposite side? No.
Same side.
Same side, all right.
It's right
Next
here,
to-
it's right here, Walter.
Yeah, okay.
Just quickly, what's on the other side of the Cooper property?
Where the right-of-way is to go down, it's another residence.
The Lot 13.
Oh, Lot 13? Oh, okay.
Built in 17, yeah. Yeah,
What?
yeah. Nice to meet you. I knew the prior owner, so I didn't realize, but anyway, my understanding when I went in and got some paperwork from Mrs. Vieira was that originally that property, when Mr. Braga was the inspector, was deemed buildable because it was connected to, it was all one estate.
No, it was separate,
So it was still separate at that time?
correct.
Okay. So what has made it unbuildable at this time?
A different interpretation from a different building inspector.
Okay, all right. And in the meantime, all these other tests have been done, perk tests and
That's
building?
got nothing to do with us.
Okay, all right,
Those are things that if we were to grant the relief that they're seeking, those are things that they have to satisfy, and that's beyond our purview.
okay, all right. Well, I can only say, I stand in objection because I just don't think it's an appropriate place to build a house with the power lines there, the water issue. You know, I don't even know where they're looking to put the house on this piece of property. I just feel it's unfortunate that these people bought a piece of property and spent that money, and it may come down, you know, I don't know if it should have been pursued differently to assure that it was going to be buildable, or if the law could have been interpreted any different.
In their defense, they did get a letter from a building inspector, who was basically the chief zoning enforcement officer, that says it's a buildable lot
For this town.
from
Right,
this town.
right. And now he's told it's not.
Now he's told it's not.
There's a different building inspector who looked at
Okay,
it and said, no.
so that's like,
It's a difficult
issue.
it's a difficult situation all the way around.
exactly,
We
exactly.
don't like these situations at
Right.
all.
Right. Do I look at, in my opinion, where the right-of-way is, next to 150 Chase Road, where 146 goes in, 54 feet is like, what? Is it?
That's allowed by our town bylaw.
I know, but it's just,
That's not a right of way, that's
It's
his
actual
land.
frontage, and it needs a minimum
That's
of
the
50
front.
feet. It needs a minimum of 50
right,
feet.
okay, all right. No, I'm just saying, I think it's just an unfortunate situation. I have sympathy for these people, but I just don't, it's just a weird place to put a home, and I'm concerned with the other, you know, the,
Can I ask a question, Mr. Chair? Is, where, you mentioned UMass Dartmouth. Where is UMass Dartmouth? I see there's an easement for
okay.
Edison. Where is UMass Dartmouth in this picture here?
I walked to UMass
Can
Dartmouth,
you-
right through the woods.
What? I mean, I don't see it. Can you show us where UMass Dartmouth is?
It's west of the New Bedford Gas and Edison easement.
Yeah, right here,
Right.
they're right here, but the water comes down below, and they own all this land.
But as I understand, there's nothing built here, right?
Oh, no, that's all wooded area and
Okay.
Power lines.
Power lines.
It's all the power lines and
Yeah.
wet. and-
Well, according to
The
this
state-
map, the power lines, that's
Yeah, but
the
from-
dimension,
Right
right?
here, and from here step forward, UMass owns all that land.
Okay.
Yeah.
But there's no building, UMass
Oh,
hasn't
no,
built
no,
back
no,
there.
No.
But they build up here,
Yeah.
and the water goes down.
It's a natural contour
It's
of
an-
it.
yes.
The elevation drops considerably in that area.
Yeah. Anybody from UMass here today?
Thank you, Mrs. Brito. Is there anyone else in the audience that would like to speak in opposition to this petition?
Good evening, Jeremy Carrero. I am the owner for 138 Chase Road.
Is that the property that abuts the entranceway there, the 50-foot?
Correct, to the right, map 13.
You're on the north side of that
Lot
entranceway.
13?
Lot 13,
Lot
yes.
13,
I
good,
think
thank
that's
you.
map 49 at that point.
Yes, 40.
No, 4513.
45?
Yep,
Okay.
according to what I have here.
Yeah, so I was having a hard time trying to understand the hardship that Mr. Medeiros was trying to prove. From what it sounds self-created, that this 50-foot easement for this property, in our area, the zoning minimum footage is 200 feet, Zone B. So I don't know why it would get approved for a 50-foot zoning in that area. Being a direct abutter, you know, I've only owned the property for about 3 years myself. But, you know, that's a very tough spot back there to own a
Said
house.
Mr. Correa, your name is Mr. Correa?
Carrero, yes.
So, Carrero, I apologize.
Yep, no problem.
So, look, zoning is a very complicated animal, I'm gonna tell you right now.
Absolutely.
And I don't profess to know zoning, and I've been doing it for 30 years. But if a law is in existence prior to the implementation of zoning laws, you have to understand that in the early 1900s, even up to 1950, there may not have been zoning bylaws in the town of Dartmouth. They didn't exist.
Yep.
So if a lot had a minimum frontage of 50 feet, and there was never any common ownership with any adjoining lots, and it had 5,000 square feet of actual square footage of area, and 50 foot of frontage, it's a buildable lot.
But was this lot tied to the 150 that they had originally
The thing is
spoke
there's,
of?
I guess there's an issue of interpretation as to whether or not an individual holding title and a trust holding title to an adjoining lot is common ownership.
Understood.
And even, I don't even know if the courts have actually rectified that. So this is an area where the chief zoning enforcement officer has discretion, and they have their own interpretations. Myself and Attorney Human, he's just slightly older than me, not much, but he and I, we've had debates on legal issues.
Right.
And he's right, and I could be right, but we don't necessarily agree on what the outcome of that issue should be. And we respect each other, and we understand that the outcome is gonna be determined ultimately by a judge or a jury.
Yep.
And unfortunately, here today, given the issue we have before us, this building inspector, and I'm not questioning our building inspector and saying that he's wrong.
No, absolutely,
I'm not
you're
saying
right.
he's wrong, and I'm not completely saying that Joe Bragger's right. I'm just saying that that was his interpretation at the time.
Yep.
Had they built this back in 2023, when they received this opinion, he would have given them a permit, we wouldn't be here, the house would be there already,
Correct.
right? So you gotta kind of look at it from that perspective. The other thing is this, I'm always concerned about the inconsistency that occurs when government says one thing one day, and it says something else another day.
Correct.
These people, I believe that they really relied on this letter from the building inspector. I, as an attorney, have asked other building inspectors for my clients to issue these letters. I rely on these letters.
Yeah.
To pull the rug out from under you after the fact is certainly something that I think challenges government.
Now, has it only been deemed not buildable once by the current building inspector, or was it not buildable before, and now at some point it was buildable, and then we're going back to not buildable?
No, but again,
Because that's what was told to me originally when I came and asked about the letter.
what I do know is I have a letter from Joe Braga, and I've got a letter from, what's the other gentleman's name? Current, Randy Bissett.
Okay, yeah.
Is there another one?
Yes, there's another
There's another
letter.
one. Okay.
If it was non-buildable before, then it was buildable, and then we're going back to non-buildable, it almost seems like somebody got paid off somewhere in between there.
Well, I don't like to use those words.
I apologize,
All right,
but
I don't like to use those words, but again, what I told you is, there's interpretation issues that go on with this.
Correct.
So, we could get another building inspector next month. If our building inspector were to leave, we get
Absolutely.
another one next month, and he says it's buildable based on his interpretation of it.
yep,
And that's why you have judges, you have appeals court, and then you have the Supreme Judicial Court, which makes interpretation, and they're the final,
Right.
right? So, on this, we will be the final determination, and then if we don't grant it, Because basically what they're saying is they're appealing the decision of
The
the
building
zoning
inspector.
enforcement officer. They're saying, look, we relied, right? We relied, and when he uses the term detrimental reliance, that's a cause of action, right? So if they don't, I'm not gonna speak for him, but what would you do if you were in their shoes and you were to lose this, right?
No,
You're gonna-
absolutely,
You're gonna be
but-
looking at someone to go after, correct?
It's like, just like Mr. Maderas mentioned, you know, they were trying to do their due diligence. There's a lot more due diligence that needs to go into that, especially perk tests and everything else, which I know we're not here to talk about.
That's not the issue. That's not the issue.
They got a letter, they
Knowing-
got a letter from the building inspector when they bought, before they bought this lot, that said it's buildable. So that's all I can say. That exists, they relied on it. They bought it, it's not like they bought it first and then they got the letter. They got the letter and then they bought the lot, and they had already done some due diligence before that, but that was other issues. That's with.
Yeah.
That's
Yeah,
got
I
nothing to do with us.
understand. Yeah,
Us
nothing to
has
do here.
It has to do with the buildability. All I know is someone came before us with something similar
Yep,
last year, and we granted it. We had a building inspector prior to that had said that it was buildable, current one said that it wasn't, and we honored the one that was previously granted.
understand.
Now, if they were always consistently saying no, we wouldn't even be involved.
Correct.
We're not gonna step in unless he's done something, wrong. And I'm not saying our building inspector's wrong.
No,
I'm not saying that at all. And that's his interpretation of it.
understood. Yeah, I was just trying to understand the hardship, that was all.
Well, the thing is this, hold on. The hardship is a buzz phrase for a variance. This is not a variance. This is not a variance. So you're kind of intermingling the two. And.
But it's
if they-
still in
if they-
regards to the zoning of the property, isn't it?
No.
Well, I disagree with them. It does have to do somewhat with zoning to the extent that it's impacted by zoning. But here, they're only asking for a determination that we rely on the prior building inspector's determination and not the current building inspector. And the
Okay.
reason they want that is because they have detrimental reliance on that decision.
So having approved that hardship has nothing to do with being the buildable lot or the frontage?
That's another battle. That's potentially, if we say no to this, then they can file for a variance. And if they file for a variance, then they have to show hardship as to why they should be able to build on this lot. That's a whole nother test.
Okay.
That's more difficult to attain. That's why I presume their attorney's deciding to do this here today.
Yep.
I don't want to speak for them.
Yeah, sorry.
I'm not here to speak for them, but I know this. If I had one of these and I relied on it, I'd be looking for blood if I weren't able to get what I was supposed to get.
No, absolutely, and I feel bad to whoever sold the lot thinking it was, buildable or, even having to go through this and hire lawyers and whatever else, but
Well, I hear you.
that's the chance you take when you buy the property, I guess, right?
There are risks.
That's really
why-
not the
but-
chance when you do your due diligence, and I think in this case, what you're talking about, first, this is not a hardship, as Mr. Madera said.
Correct.
And I'm looking at this case saying that there's an attorney involved in it, and I'm looking at everything. He did his due diligence. And I think as citizens of this town, when you live here and you build here or you're living here, you rely on your government. Mr. Maderas, the attorney, Mr. Maderas, Jeffrey, sent a letter and he asked for a zoning determination and he got it. It has nothing to do with perk tests, as Mr.
Yeah,
Maderas
yeah,
said. That's not our issue here. The issue is, these people paid $200,000 for a lot that this town told them that was buildable. We've had this issue before where somebody is paying taxes on a buildable lot.
Yeah.
Paying real estate taxes and pretty healthy real estate taxes. Taxes aren't cheap around here.
Oh, yeah.
They're paying taxes on a buildable lot, and then when they apply for a building permit, somebody, and I'm not criticizing the building commissioners, they have an opinion, that's why we're here, to oversee it to some degree. The building commissioner comes in and says, it's not buildable. You've been paying taxes for 20 years. In one of the cases we had, somebody's paying taxes on the buildable lot for 20 years.
Yeah.
Now they can't build.
Yeah.
We're here to help people, to give them a relief if they deserve it. In this particular case, and I know Mrs. Brito said about the water issue, and that's not an issue for us right now. If there is a water issue, that's got to be somewhere down the line with what UMass is doing, the building, that's, the issue here is,
Yeah.
are we gonna
'Cause
give
they
these
just
people relief
redid
for a
some of
buildable
that,
lot?
too.
And one of the things that came up a couple of times is somebody said that there's an easement going in there. That's not an easement, that's a frontage.
Correct.
And as far as I know, I don't know much about real estate, according to my two brothers here, but I do know that if it had more than 50 foot of frontage before zoning, that complied with as long as, I think, 5,000 feet, was it? This lot is what, 10,000 feet, 10,000 feet of uplands, 50 feet. I mean, it's probably the biggest lot in the area.
Yeah, it goes behind 4 or 5
100,000
houses.
square feet,
Yeah, 300,000 square feet.
and 105,000
Yeah.
is upland.
I mean, it's the biggest lot in the area there,
Well,
and,
the house
and they paid $200,000 for it, and somebody in this town, and I'm not criticizing, because I think the commission did a good job, but said, you can't build on it.
Right.
Now, what do?
Yeah.
You
'Cause the house
file,
would
you
be
file
facing-
something for relief.
The house would be facing all our backyards first off, you know, but
I'm sorry, I didn't hear you. The house would what?
the house would be facing all of our backyards, you know, so.
Well,
The way it-
I don't know, your house is facing your side neighbors too.
Yeah.
I mean, you know what, you're
Used to
not
be the old
living in a
Kings Philip
bubble here.
Highway there.
That's not our concern where the backyard is and who's looking in there.
Right.
I just feel, I feel that the town has an obligation, and if they say it's buildable and somebody relies on it, and somebody comes in and says, I just put yourself in that position.
Yeah.
What would you do if you spent 200,000? Would you sue the town?
No, absolutely, but.
Absolutely, you sue the
No,
town.
I wouldn't go after the town. I'd have to go from.
You'd go after anybody. You'd hire a lawyer and they'd go after
Yeah, absolutely.
Joe Zilch if they had to, right? You want
So-
your $200,000 back. That's all. I mean, I feel that, I know the area quite well there, and I've lived in Dartmouth all my life. This is a great big lot. It's gonna be facing somebody's backyard. I mean, the guy's got a paradise back there, if you really think about it, more than these other people that are facing the street on Chase Road, but that's not the issue here. The issue here is that, did these people do the due diligence and rely on representations from the town of Dartmouth that said it's a buildable lot? And as a result of that letter, they put $200,000 down. That's not peanuts.
No, absolutely
You know,
not.
that's
yeah.
not peanuts, and so we're here as a appeals board, and as Mr. Maderas quite aptly said, they could ask for a variance.
Yeah.
Right? I mean, there's another step, but our job is to find out, is it a buildable lot? It's not to find out whether there's drainage problems there.
Right.
That's got to be addressed with other boards, and it will be
Yep.
addressed. Conservation, Board of Health, other boards. But in my opinion, I think that the lawyer that handled this case, I don't know who, Mr. Maderas there, did a great job. I've read the letters. He did his due diligence, and he relied on representations from the town. The town said it's a buildable lot. And then we got a new building commissioner, and I respect him. He had a different opinion, and it all comes down to this common ownership, not the shape of the lot.
Yeah.
I think the whole decision, and we've had that before, where common ownership is, I've made mistakes like that. I'm a lawyer, unfortunately. And somebody comes in, and if I don't know, but if you checkerboard things, husband and wife can own one lot in their names, and husband owns a lot, the next lot, and that's okay. But if they make a mistake and they, for some reason, it's husband and wife, and then husband and wife, now that's not a buildable lot.
Right, right.
And somebody made a mistake, and who's gonna pay for it? The person that paid 200,000? I don't go for that.
Yeah.
I'm here to help people.
No, absolutely.
And I think everybody wants to be neighborly.
Yep.
And I don't see that there's a problem saying that this man needs relief.
Okay.
Thank you.
I thank you. Is there anyone else? I know Mr. Tully wants to speak, but I want to give someone else an opportunity. Is there anyone else that would like to speak in opposition? All right. Mr. Tully, if you'd like to come up. If you could just identify yourself again, just for the recording.
James Tooley, 176 Chase Road. The question I have is, looks like two directors of inspectional services of the town said it couldn't be built, and one person said it did. Is that correct? Because in 2019, a letter to Mr. Cooper by David Ricciuni, whatever, said that that wasn't a buildable lot. And then in '23, Braga says it is, and then now the new one says it isn't. So in a sense, you've had two.
That's correct.
Yep.
Yeah.
So it's like who's on first and who's on second. I mean, I feel bad because I agree. If I paid $200,000 and thought that this letter was a correct letter, I would want relief. And so I agree that these people shouldn't be out their money because of this letter that maybe he thought he was doing the right thing, I'm assuming, Mr. Braga, or he felt he was interpreting, just like Mr. Requena thought he was doing in the one currently. But so it is confusing that you've had two inspector of services saying that it wasn't a buildable lot and one saying it was. So I don't know if Mr. Maderas, the attorney, saw this letter in 2019 saying it wasn't, but then the problem was he gets a letter like this, which looks to me like it's, you go ahead when you get a letter like this. And so I realize you guys are in a pickle too, because in a roundabout way, you represent the town of Dartmouth and don't want to be sued. So, and I don't know whether that comes into your decision-making process about how you're going to make your decision of, in your line maybe, I'm doing this to protect the town versus is it the right thing to do, or because you don't want the town to have to pay $200,000 or whatever they're going to sue you for, or what?
How about us? Rather
Or,
than
I
you?
know, us. Oh, yeah.
Okay.
I pay taxes, and I have I've owned the house since '78, so I've been here a long time. And so if they deserve getting whatever they get back of what they've paid out, in fact, if you deny it.
You've hit the nail on the head, sir.
Yeah.
Thank you.
Yep.
Mr. Chair, I just want to point out, this gentleman brought out that letter. There was another decision, but that wasn't addressed to Mr. Maderas. That was addressed to
No,
Mr.
I'm
Cooper.
looking at it now.
Right.
He did say that.
No, I know that, you said that, but one of the things that I'm concerned about here is that as lawyers, we struggle with this common ownership type thing.
We do.
And I would have preferred if the building inspector or the commissioner at the time had said, I'm going to refer this to town council, because we got a letter here, nobody did the title search. And Mr. Maderas brought out the fact that different ownerships, and that's the problem with all of these cases with common ownership, is that somebody can look, if they didn't do a title search, if there's one name different in it, it's not common ownership. That was the issue I think we had with the Nonquick property, where some woman had a lot that she was paying taxes as a buildable lot. Her mother died, and the mother's death put the property in an estate, and all of a sudden it was deemed that her lot merged with the other lot where she had siblings there, and you know what, one lawyer, I don't think it was a lawyer, but it could have been the building commissioner, said it now merged, where when a legal opinion came out, it said it wasn't a merger because it was different owners. So these things are complex, and that I think in the future we should not instruct the building commission, but at least advise them to say,
Well, I think-
send it to town council.
I think the policy is now where they don't provide opinion letters.
Well, that's what they said, but we have a bylaw that asks for that, yeah.
It does.
Yeah.
But actually, I thought, when I say the policy, I thought it was Mr. Braga's policy at one point that he didn't want to provide opinion letters, that he wanted people to submit actual building permits, and then he would make a determination of granting or denying the building permit. But obviously, he wasn't following through with that on every single instance. And we're not here, we don't supervise the building inspector, right? He's autonomous. He's the chief zoning enforcement officer. He decides if he goes knock on someone's door because some shed's too close to the property line. That's all on him. It's when someone has an issue with him or someone seeks relief from the zoning bylaws, they come before us, and we're here sort of as a quasi-judicial board to make a determination as to whether or not relief should be granted. But I just want everyone, and I understand that you're abutters. We never want anything to change in our neighborhood. I get that. We're all here because we love this town too, all right? And all we're trying to do is do the right thing for people. That's really what we try to do every step of the way. And we do deny things. On occasion, we do deny. When it doesn't make sense or it doesn't meet the requirements of a statute or the bylaw, then we will deny it if it doesn't really apply. But when there's a situation where relief is justified when someone has been damaged or they're going to be damaged if we were to enforce the current position of a building inspector. I find that to be problematic because government has to be consistent. And if it's not consistent, it becomes, people start to lose faith in it. And I think that their counsel did due diligence because it's probably what after having seen what happened last year with someone, I don't even know if I should rely on any type of a building inspector's letter. I think we should just tell people, apply, together a set of plans, apply, get a permit, and build. And that's it. Once you do that, then at that point, you're pretty much protected. But here, obviously, for whatever reason, because had they acted the very next month that this was granted, we wouldn't be here today. The house would be there. It wouldn't be any different than where there otherwise may end up. All right, having said all that, is there anyone else in the audience that would like to speak either, and I'll go back, either in favor or in opposition to this request? Or this appeal, I should say. All right, I can represent to the viewers at home that there's no one else in the audience that would like to speak. We've had 3 of the immediate abutters speak very well, eloquently, to explain their positions on this, which we respect, right? I get it, right? I've heard you, I understand that. But sometimes we have to sort of weigh out the impact that this would have on either side. So, different gentlemen, at this point, we don't need to close the public hearing in case we have any additional questions. But I haven't heard too much from Attorney Newman, other than initially. What are your thoughts on this, Mr.
My
Newman?
thoughts are that Mr. Attorney Maderas did what he's required to do to represent a client. He sent a letter to the building department for the town. The existing building commissioner said it was a buildable lot. His clients relied on that. I think we're in a position where, as far as I'm concerned, I would accept the position of Mr. Braga.
Okay. And you, I think I understand where you sort of came, the direction you're coming from, Attorney Farrier, but is there anything else that you'd like? 'Cause Mr. Tully has certainly honed out the issues here, right? He's honed out, if we grant and we don't grant, the direction that this could possibly go in.
I just would say that, you know what, Mr. Chairman, when you asked if there was opposition to it, I would just commend the people that came here and spoke. I don't think they spoke against it. They gave their opinion as to what they thought, and very eloquently, and said, you know what, there's other issues there that really don't address us, but I think they can be addressed when these people apply for a permit, because they're going to be building, and if there's water problems there caused by UMass, I think the town's going to address that. But I would say that I agree with Alvin here that the lawyer did everything he could. He relied on the town, and that's all we have to do. I mean, if you apply, and I know that there's a couple of letters there, unfortunately, the petitioner here, apparently from what I heard here, his son died in an automobile accident, was going to build a house, and there was a delay, and now a new building commissioner comes in, and now it's a new ballgame. And it shouldn't be like that. He's already bought the property, he did his due diligence, and I think that's why we're here, to give them relief. And I think the next step is that some of the neighbors here that are here that raise some issues that are valid that will be addressed by the Conservation Commission or the Board of Health, and maybe they should be, and I'm sure they will, address UMass
I
if
think
there's a
this is
problem.
also, and I know some of the concerns, and I always like it when people come forward, either in opposition or just to ask questions, because it's promising to me to see that we have people in our town who care, right? They care about what's going on in their neighborhood. They care about what's going on on their roadway or in their immediate abutting property, to see how it impacts them, and just in general, how it impacts the entire town. And we've got big fish to fry coming up in the next week with 40B projects that are tremendous. I'll let you speak. If you got, let me just finish, I'll let you come up, okay? So I always like to hear them set forth what their concerns are. I know Mrs. Brito had indicated that she's concerned about some of the water runoff. One of the things I've come to learn, and we don't have Halim here today, who's an engineer, but he's very, very, I think he plays a great role in providing us information, and, because we hear it from other engineers, but to have it come from him, certainly, to me, has a tremendous amount of weight, is that because this is an aquifer district, there's a certain amount of recharge that they have to do with this. So in order to get a building permit for a house in this area, all of the roof runoff has to go into a gutter, into a pipe, and then it goes directly into the ground. It's not surface water, so it goes deep into the ground, so it doesn't impact any surrounding property. So there are arguments that are made by these engineers, and they're supported, that by building the home and doing a recharge system, which they're gonna require here, that water is no longer, they're displacing the water and putting it directly into the ground and recharging the groundwater. And that reduces the amount of surface water. And I understand that they're concerned, and I've come to learn that over the years of being on this board, that it actually does help. It doesn't work against people, it actually does assist them. But we do have Mr. Carrero, I think it is, that he has one final comment to make. I'm gonna allow, as long as you keep it short, sir.
Yes, sorry, so Mr. Carrero again, Jeremy Carrero. Just after you guys were reviewing, what was going on, I had a question myself, was if they had a letter saying that it was okay to build, what was the point of this second letter that deemed it not buildable?
They went to apply for a building permit.
And then this new,
New commissioner said, wait a minute.
That's not how I interpret this bylaw, so I have to find, because he wants to be consistent, right? He wants to be, just like we want to be
Yeah,
consistent
no.
with people that rely on this, we want to be consistent so that people have faith in our system.
yep. Yeah, okay, that makes sense, thank you.
That's what happened, yeah. All right, gentlemen, I'll entertain a motion to close the public hearing.
So moved, close the public,
Quick statement. Kathy Brito, 158 Chase Road, trustee. When I read all this and saw what happened to these people, I was like, you got to be kidding me, okay? This is awful, okay? And then my first thing was, these people are going to sue the town. Okay, so I think we'll all concur that what has happened to these people is terrible, and we all concur that, God, we don't want the town sued. However, my concern is this happening, Mr. Bragger's letter, the new letter, maybe this isn't the only one, and it's going to come further down the pike. And I hate to use this word, but it's always my experience in the courtroom and everything else, the word precedent. I am concerned about if you say, okay, we don't want this to happen to this people, which we agree, and we grant this, or we, void out this second thing, you're setting a precedent, okay? And it's going to go further down the road with further situations. And I think that, there needs to be, it just looked at beyond what's happened in this room, because it could expand further. I do know that Mr. Cooper had approached all of us, abutters, telling us that if we ever wanted to buy a piece of that land, we could. My mother's house is on an acre. She didn't want any more land because it was always looked at as not a buildable situation. But things change. And I just, I hope that this family finds some relief from this, and the town is cautious about how they proceed with this because of what the impact can be on future cases and situations that are brought before your board. Thank you.
Thank you. All right, so I'll entertain a motion to close the public hearing.
I make a motion and we close the public hearing.
I'll second that motion.
All in favor?
Aye.
Aye, the ayes have it. All right, gentlemen, what's your pleasure? We can
Do you have findings?
kind of put something together. I didn't know exactly where this might be going, but let's take a look. So this is very rudimentary. So obviously, these are just suggestions, okay? These are just suggestions. So the subject property is located at 146 Chase Road and is also known as Assessors Map 45, Lot 31. Subject property is located in a single residence B district. The petitioners have owned the subject property since August 4th, 2023. The subject property has 196,681 square feet.
That's
of
not
claim.
right, is it?
That's not correct.
That's Uplands.
No, Uplands is even less than that. I don't have the total amount. How about we just do acres? Oh, you got a math? You gonna add that up?
I'll Add it up.
add it up, whatever it is, the square footage of land,
Uh,
with 54.47 plus or minus feet of frontage. The subject property is improved with a, that's not correct.
Subject properly approved with the
The petitioner sought and obtained an opinion letter from previous zoning enforcement officer Joseph E. Braga, which is dated July 6, 2023. Such letter indicated the subject property for zoning purposes meets the requirements of Mass General Law 40A, Section 6, non-conforming lot, and Article 6, Section 375-6.3B of the Town of Dartmouth zoning bylaws for non-conforming lots. In reliance on the aforementioned opinion letter, petitioner purchased the subject property and expended sums of money in preparation of building a single-family home on the lot. So we have 1 through 4, and we have 6 and 8.
The total square footage is 313,676 with 105,969 uplands. The petitioner sought.
So if we were to move forward in allowing Mr. Joseph Braga's opinion letter, we would indicate that it was the unanimous decision of the Board of Appeals to grant the requested administrative appeal, to reverse the decision of Randall Bissett, Director of Inspectional Services, and to allow 146 Chase Road to be declared a buildable lot in accordance with the requirements of the Town of Dartmouth zoning bylaws, consistent with former zoning enforcement officer Joseph E. Braga's zoning opinion letter declaring such to be true.
Sounds good to me.
All right, so I'll entertain a motion if there's a motion, gentlemen. And if there isn't, there isn't.
Do we have a number on that?
Yes, it is. Oh, I'm so disheveled here right now. Oh, AAPL 25-1.
AA?
PL 25-1.
All right, so I'll make a motion on AAPL 25-1, that we declare that this be a buildable lot, and in accordance with what the chair just read into the minutes.
Second that motion.
All in favor?
Aye?
Aye.
Aye, the ayes have it. Good luck. All right, moving on, gentlemen. The next matter on tonight's agenda is variance case ZAV 25-7. The petitioner is John Romanelli, and the owner is Aries and Susan Giesta. Subject property is located at 14 Galleon Drive, also known as map 186, lot 3-1. It's located in the general residence district, and the matter was legally advertised on June 19th and June 26th of 2025.
I make a motion that we waive the reading of the abutters list. Second.
All in favor?
Aye.
Aye, the ayes have it. The petitioner is seeking a variance to reduce side yard setback from the required 15 feet to 5.6 and increase lot coverage beyond the maximum of 50% allowed to 52.3 in order to build an attached 672 square foot ADU to the existing single-family dwelling. The lot was created as part of the Woodford Estates subdivision plan endorsed on September 24th, 1990, with 15 feet side yard and 20-foot front setbacks. They're seeking relief under Article 375-10.4F Development Standards. So we've got some comments from boards. Actually, let's go to the building inspector's letter first. Yeah, I started reading it before, now can't find it. So this is a letter addressed to, no, that's not it. John Romanelli, and it's dated June 2nd, 2025. I've reviewed your application, and at this time, your proposal cannot be approved due to noncompliance with current zoning regulations. Applicant proposing to build attached 672 square foot ADU to existing single-family dwelling. This lot was created as part of the Woodford Estates subdivision plan endorsed on September 24th, 1990, with 15-foot side and rear, and 20-foot front setbacks. The addition as proposed seeks to reduce side yard setback from 15 to 5.6 and increases lot coverage beyond the max of 50% allowed to 52.3. Your application is being denied under the following sections of Dartmouth zoning bylaw, and it's the general residence district, all uses on a lot which include but are not limited to building structures, driveways, parking areas, gravel areas, walks, patios, storage areas, impermeable surfaces, etc., shall not cover more than 50% of the lot. Natural areas such as landscaping, garden lawns, etc., are not regulated within the 50% requirement. He doesn't mention the bylaw that has to do with the setback, but there's a bylaw that speaks to that as well. All right. The town departments, to start with planning. This lot is subject to the conditions outlined in a special permit granted by the planning board dated January 23rd, 1990 for the Woodford Estates definitive cluster subdivision. Board of Health, town water and sewer, just letting us know. Conservation, no conservation issues here. However, review of the site plan and the Mass GIS assesses property lines indicates that the site usage to the rear appears to extend beyond the actual property line and onto an adjoining parcel. Just an observation, Mark Garrett. We're aware. DPW, the site plan shows the existing water service, but not the existing or proposed sewer service. Please explain how the new ADU will be connecting to sewer. Compliance with the town DPW regulations is the usual standard regulations that they list. And the fire chief says, must comply with Mass Building Code 780 for heat, smoke detector placement and upgrade to the entire dwelling as required. Given that they're connected, there probably have to be some hard wiring that goes on between the two, but he will do the final inspection. I'm sure the building department will tell him what he needs to do with that. All right, we also have a letter from Mr. Sean McDonald, the property manager, and he's writing to us to let us know that attached is a map of a portion of the Woodford Estates Trust to which the subject property is located. As seen on the map, there is a buffer zone that cannot be used for any use by the residents and must be left alone as part of the approval process by the planning board back in 1990. I've also attached the highlighted map of the area. I manage the Woodford Estates Trust and have done so since 2001. And it's from Mr. Sean McDonald in his capacity as the property manager for North Dartmouth Properties, who I believe runs the association or manages the association as part of this subdivision. All right. Gentlemen, so at this time, I'm going to call upon the petitioner or their representative to come forward and state their case.
Good evening, Mr. Chair, members of the board. Attorney Mac Long here on behalf of the petitioner, Mr. and Mrs. Giesta. As the chair had just read in, we are here regarding a variance for the subject property located at 14 Galleon Drive for the addition of a 672 square foot ADU. We're requesting a relief from the 15-foot side yard requirement and also relief beyond the maximum lot coverage from 50% up to 52.35%. A little bit of history here. The Giestas have lived in this residence for about 29 years now. They are looking to add this ADU for the Mrs. Giesta's mom, his mother-in-law. She's an 80-year-old woman, currently lives on her own, and they are looking to construct this ADU so that she can move into the residence with them while still retaining an area for herself, as we can all appreciate and understand. I have two letters here from the direct abutters, both to the we'll say northeast and northwest, both right and left abutters when looking at the property. And I believe we have abutters here from the rear as well to speak in regard to this. If the board would like to see the letters.
Sure. And when you say to the rear, do you mean on that buffer area, on the other side of the buffer area, so they actually front Milton Street? Okay. So I can read into the record. We've got a letter here dated August 12th. And it's from Kenneth Ferreira. And he says, I'm writing this letter to support Aries Giesta's application for an attached accessory dwelling, ADU at 14 Galleon Drive. I are the direct abutters at 12 Galleon Drive. I have no objection to proposed attached accessory dwelling unit, and I encourage you to grant the variance for this attached accessory dwelling unit. And there's another one, with the same words, from a Michael Naylor, and he is from 16 Galleon Drive. And same, basically saying that they encourage us to grant the variance for this attached accessory dwelling unit. So I've read these into the record, they'll become part of the record. Excuse me?
Quick question for you, which one is the one that's closest to the
Yes, he just
ADU?
submitted.
16, is it not? Mike Naylor
What is it?
is closest to the ADU.
Yes, the closer to the ADU is 16?
Mike Naylor.
Mike Naylor, okay. So if I'm to understand correctly, I just want to make sure we got this right. On this map, are you able to tell me which one is your client's property? And I'll give you a pen, you can mark it off with an X. Well, 4866 is here, if you look at here, and I think you're 65, 4865, right? I just want to make sure we remove that any doubt. Okay, great, so I can show these gentlemen. All right, gentlemen, according to this, it's that lot.
Right here.
Yeah,
That one I circled, did you circle it on your?
no, I didn't.
So, counsel, you heard me read into the record, and you've seen this plan, where there's some
have that plan in front of me.
You've got some encroachments going on here, right? So what can you tell us about these encroachments? Because obviously, they've been raised, we're not here raising these issues, but obviously, the plan has to show them, right? This person who did this plan did it right, this is what they have to do. And the, I guess the individual who sort of runs, let's say, the association, for lack of another word, has indicated that there's not supposed to be anything back there. So what's your understanding about what's going on?
I understand that that was put in years ago, and I don't believe that my client had any, survey work done at that time. It is just vacant land. I understand that there's not supposed to be anything in there, not making excuses, but, there appears to be nothing going on there. My client may have just at that time understood that to be his property, and only recently, when the survey was completed, came to understand that there may be a few encroachments here. It looks like about, the engineer did not show about how deep it is, but it looks to be, maybe 15 or 20 feet into that area, owned by
We'll
the
call it a buffer area for now?
buffer area for our sake, yes.
What did he do, though?
Well, if you look at this plan, there's a shed and there's a paver.
And some pavers, it
Well,
looks like.
I'll be honest with
He's
you,
in the
at first
buffer
glance,
area.
All right, I didn't see that on that map, yeah.
so at first glance,
Pavers and buffer,
Shed,
yeah.
he's got pavers, he's got a stockade fence.
Okay, I didn't see that, thank you.
I presume he's not probably the only one that's
No,
actually encroached onto this?
when I looked at the GIS, it does appear that, it is kind of a commonplace thing across this development.
All right.
I guess it was part of the plan that was approved by the planning board in the 90s, so that's the need for it, doesn't make a ton of sense now, maybe, but that's what was approved at that time.
Oh,
I'm
yeah.
not here to enforce other people's and other boards' determinations and whatever it may be. I don't know enough, and that's not really
It seems to me that the property manager would be the person that would be.
bring an action to enforce it, right? And if they're gonna bring it, if they have to bring it before us, it's us, or,
Clearly, there should be nothing in there because it's on record at the registry that this whole development was put together with the understanding there'd be nothing built in that area.
I think that understanding would have been, inferred by the developer, but per my client, he bought his house and may or may not have understood that. Could a little bit more due diligence have been done? Sure. But as Mr. Chair mentioned, I don't know that.
well, I do know this. Nothing of what's being proposed here tonight does any further encroaching into that area.
Absolutely.
Not my understanding? Fair?
Agreed.
All right. So nothing we would be granting would be causing any further issues with that. And I'm not here to look for other concerns. At this point, they're looking for a certain amount of relief. That's me, that's just my thought, I'm sharing it out loud. You gentlemen, if you have any concern about that and you think we need to require something else, I leave that up to you to make those comments.
No, I don't think that is the issue that the zoning board should be looking at. We're looking at strictly the ADU and the 5'6" distance
I agree.
from his.
As well as the lot
neighbor's
coverage.
Property, his neighbor has no objection to it.
Now, whether or not he's gonna have issues with the building inspector after, he is the chief zoning enforcement officer. He's here to enforce.
Yes.
We're here only to interpret and grant relief.
Understood.
We're not necessarily the enforcers. So, at this point, I understand the petition. So basically, it's two things. It's the setback and it's the percentage.
Yes.
All right. Thank you. I'm sorry I didn't recognize you at first, because you have a
Worries.
beard now, so I didn't recognize you.
I do.
All right. Is there anyone in the audience that would like to speak either in, well, let's start with in favor first. Anyone in the audience that would like to speak in favor of this request? All right, we got someone here?
Yeah.
Kindly come on up. Don't, Don't be afraid, we don't bite. Come on up, just state your name and your address.
Yes.
We always like having people coming forward.
Yes, good evening, gentlemen. Ma'am, thank you for the opportunity to speak. David Harris, 15 3rd Street.
What street?
15 3rd. I'm the abutter on the, I guess, the rear. The other side.
Chambers Street, that's there, 3rd Street? Okay, I know where it is now, okay. There's 2nd Street and then there's 3rd Street, fair enough. So your house actually faces Milton?
Well, it actually faces 3rd
3rd
Street.
Street, okay, so I get it, it's one of those, I drive by there, but don't
Okay.
ever- it's a quiet neighborhood, right? So we don't really, no reason to really be looking down that way. So you would be pretty much impacted by this as well?
Yes,
What are
sir.
your thoughts?
Well, excuse me. I am here in favor of Mr. Jester's endeavor to expand his house. Mr. Jester's been a good neighbor, not just to myself and my wife, but for the neighbors around him. He has always been there looking out for the welfare of others, giving a hand, whether it's a physical hand, knowledge, or making recommendations to someone else, what is best for them. He has always looked out for the welfare of others, of those around him. So in that respect and regards, the fact that he is willing to expand his house for his mother-in-law, it speaks to his character, looking out for someone else, and I think at this point he deserves that right to do something for his mother-in-law and also for himself. So,
Thank you,
that's the,
Thank you.
that's the short of it, and I thank you for your time and the opportunity.
thank you.
David, I always admire somebody who wants to do something for the mother-in-law, but usually doesn't work. I admire that.
Yes, come on up. Please just state your name.
Cynthia Harris, 15 3rd Street, South Dartmouth, right with that little piece of thing there, whatever they call it, but.
3rd Street?
Well, no, because I am on 3rd Street, but that back doesn't bother us at all. It never really did. It's
You're
a,
talking about the buffer area?
yes,
there.
the buffer
Okay.
area. I'm sorry.
No, I just wanted to
should
make
be-
sure
I should be good at this. I was a court reporter, and I worked for the City Hall in New Bedford, but sometimes you still get a little nervous when you come in front of people. So anyway, I'm in favor of it also. And I think my husband hit everything on the head that, especially for his mother-in-law, because we're all getting older, and for someone to have that concern, I think that's a beautiful thing. And I don't think it's going to hurt anybody, and I'm all for it. So hopefully he gets granted, and thank you for your time.
Thank you.
Thank you.
Thank you, Ms. Harris.
That's always nice. Is there anyone else that would like to speak in favor of this petition? Is there anyone that would like to speak in opposition to this petition? I can report to our viewers at home that everyone that would be willing to speak either in favor or in opposition is either here or they're not present. So at this point in time, unless my board members have any other questions of the petitioner's representative, I would move into some proposed findings.
Are you closing the public hearing?
No, I don't do that yet, just in case we have questions, Attorney.
Oh, okay.
Farrar. I do it after I read it into the record, because sometimes we need some facts. Additional facts that may need to be clarified. The subject property is located at 14 Galleon Drive and is also known as Dartmouth Assessors Map 132, Lot 48-65. The property has been owned by Aries and Susan Giesta since October 1998 and is located in the General Residence Zoning District. Subject property is a pre-existing non-conforming lot and was approved as part of an open space residential subdivision development. The petitioner seeks to construct an accessory dwelling unit, hereinafter ADU, a distance of 5.6 feet from the side yard property line where 15 feet is required. The proposed ADU will increase lot coverage beyond the maximum 50% allowed to 52.35. Petitioner seeks relief from 375-7.4D setback 2B, which requires a building or structure must have a 20-foot minimum setback from all other perimeter property lines. The petitioner also seeks general relief from 375-10.4F, percentage of lot coverage, which requires in general residence districts all uses on a lot which include but are not limited to building structures, driveways, parking areas, gravel areas, walks, patios, storage areas, impermeable surfaces, etc., shall not cover more than 50% of the lot. The board finds that the requested variance meets the statutory requirements of Mass General Law 48, Section 10. One, there are circumstances related to soil, shape, and topography that especially affect the subject property that do not generally affect the zoning district in which the structure or land is located. My reasoning, and I'm open to any interpretation, gentlemen, I always have difficulty with these. Counsel for the petitioner, Mr. Long, can prepare these in the future. He'll have to prepare these for us. The location of the existing structure in relation to the perimeter lot lines limit the petitioner's ability to further expand the structure. The board finds that after review of the submitted plans, that the nature of the proposed ADU is proposed in such a manner that it will be appropriate to the natural topography, soils, and other characteristics of the proposed site. Subpart 2. Are we on a plane? Sound like,
That's your 6:30.
oh, is that what it is? 2, a literal enforcement of the provisions of the bylaw would involve substantial hardship, financial or otherwise, to the petitioner. A denial of the ADU would create a hardship upon the petitioner, as he would not be able to provide adequate housing for his family. In this case, he's going to allow his mother-in-law to live there. I kind of share the same sentiment as Attorney Farrier, but it's on him. Number 3, desirable relief may be granted without detriment to the public good. Granting the requested relief would not create any detriment to the public good. The ADU would be in keeping with the general character of the home and the general neighborhood. And number 4, the variance will not nullify or substantially derogate from the intent or purpose of the bylaw. The proposed ADU is aesthetically pleasing and is keeping with the intent or purpose of the bylaw and is in harmony with the character of the neighborhood. And the usual conditions, which state that you got to get approval from all boards and agencies, all of the town, what is it? Town administrative boards, whatever they may be. So it'd be Conservation Commission, which really doesn't apply here. I think his biggest issue is going to be DPW. They're going to require an additional plan. They may require additional plan, Attorney Long, that's going to set forth where the sewer and where the water line is going to be to service this. So I would strongly suggest that they have that before they submit the building permit application, because they're going to need it anyway. And that's about it. Anything else, gentlemen? I'm open to any interpretation. Listen, this is the best I could come up with. We have to be creative as well as we can. Well, I appreciate your creativity. Yeah, well, I'm gonna place the request next time on you, Attorney Long, to be creative. So, I'll entertain, if we don't have any other questions of the petitioner, and we're okay with some of the proposed findings and the statutory requirements, I'll entertain a motion to close the public hearing.
I move we close the public hearing for ZAV 25-7.
Second that motion.
All in favor?
Aye.
Aye, the ayes have it. What's your pleasure, gentlemen?
Me or you?
I'll-
I make a motion that we approve case ZAV, variance case ZAV-25-7 with the proposed findings and conditions previously read.
I'll second that motion.
All in favor?
Aye.
Aye, the ayes have it. Congrats and good luck. And folks, thank you very much for coming in. It always is very comforting for us to know that there are people that are supporting this. Thank you.
Dave, nice to see you. Always a pleasure. Nice to see you. Good, good. You doing well?
On that whole side of us, that development, was development on it, so.
So you know what goes on.
Yes.
All right. Thank you.
Thank you.
All right, so we are still in session, and at this point in time, I'm going to move on to the administrative portion of tonight's meeting.
Okay.
Yes.
Good night. Good luck.
Moving on, we're moving on to review and approval administrative minutes of July 23rd, 2025. Any comments, gentlemen?
I have none.
I have none.
I'll entertain a motion.
Move we
Excuse
adopt
me,
the-
folks, we're still in session. Thank you. All right,
Move we approve the minutes of the meeting.
well, I just need something specific. It's the minutes of the meeting of July 23rd, 2025. Can I get a second on that?
Second.
All in favor?
Aye.
Aye.
Aye, the ayes have it. Next is review and approval of variance ZAV 25-4 minutes of July 23rd, 2025 of 25 Thatcher Street.
I have nothing to add.
I do not have anything to add.
Neither do I.
I make a motion that we approve the minutes of variance case ZAV-25-4 for July 23rd, 2025 for 25 Thatcher Street.
I'll second that.
All in favor?
Aye.
Aye, the ayes have it. Review and approval of special permit ZSP 25-4, minutes July 23rd, 2025, for 46 Lakeside Avenue.
I have nothing to add.
I do not have anything to add.
I make a motion that we approve the minutes for special permit ZSP-25-4 dated July 23rd, 2025 for 46 Lakeside Avenue.
I'll second that.
All in favor?
Aye.
Aye, the ayes have it. Review and approval of variance ZAV 25-6, minutes for July 23rd, 2025, for 33 Westwood Drive.
I have nothing to add.
I
Neither
have
do I.
nothing to add.
I make a motion that we approve the minutes on variance case ZAV-25-6 for July 23rd, 2025 for the property 33 at Westwood Drive.
I'll second that.
All in favor?
Aye.
Aye, the ayes have it. That ends the administrative portion of tonight's meeting. If there's any other general business, we can bring forth anything that needs to be, that you gentlemen want to comment on.
Oh,
I know that we need to have, after this, we need to have a discussion with Michelle, unless you want to do that on the record, Michelle, I don't think there's a need. It's just dates of our availability for the 40B projects that are going to be coming before us for the first time a week from today, and then thereafter, each and every meeting that we're going to be able to schedule. So if there's nothing new, I'll entertain a motion to adjourn.
so move to adjourn.
Second that motion.
All in favor?
Aye.
Aye, the ayes have it.